Hello, how are you today? I am an ex-professor John of Korea Maritime and Ocean University. I am an expert in seafarers related issues, and I have a lot of experience of participating in both IMO and ILO conferences and meetings since early 1990s. That's a brief introduction of myself. This lecture intends to provide you with a basic knowledge and understanding on the system of Seafarers Act and Ship Officers Act. Part 1 is related to system of Seafarers Act. I would like to talk about the following areas in the Seafarers Act, namely general provision, master duty and authority, maintenance of order on board, seafarers' employment contract, wages, minimum manning, provision of food, safety and hygiene on board, and penalties. However, I would not be able to explain them every detail since we have a quite limited time. Before talking about Seafarers Act, I would like to touch on some of the relevant provisions in the Constitution of the ROK. The preamble includes the notion of affording equal opportunities to every person and elevating the quality of life for all citizens. More specifically, Article 34 sets out that Para 1, all citizens shall be entitled to a life worthy of human beings. Paragraph 2, the state shall have the duty to endeavor to promote social security and welfare, and Article 32 stipulate that all citizens shall have the right to work. The state shall endeavor to promote the employment of workers and to guarantee optimum wages through social and economic means, and shall enforce a minimum wage system under the conditions as prescribed by the Act. Turning to labor laws, there are 3 laws, namely Labor Standard Acts, Seafarers Act, and Public Officials Remuneration Regulations. The first is for all shore workers. The second is for seafarers and fishers. And third is for civil servants. Talking on Social Security related laws, which include National Health Insurance Act, Industrial Accident Compensation Insurance Act, which is not applicable to seafarers, Employment Insurance Act, National Pension Act, which is applicable to all workers, including seafarers. However, there are other pensions applicable to public officials, military or private school teachers. These other pension schemes are more favorable than that of national pension. Many scholars recommend that the pension system needs to be rationalized to make it sustainable and reasonable. Regarding the special nature of maritime labor, based on ship community theory, i.e., common risk and living community on board, it is characterized as isolation, high risk, discontinuity of maritime labor, hardworking conditions, and early exhaustion of maritime labor. That is the reason why Seafarers Act was enacted, apart from Labor Standard Act in this country. The preamble of MLC also recognizes special nature of maritime labor, namely global nature and the necessity of social protection. Therefore, the labor issues on seafarers are recognized to be treated specially, both internationally and domestically. Talking again on the legal nature of Seafarers Act. Firstly, all articles and provisions of the Act are mandatory. Secondly, the Act contains public law as well as private law. The former are related to the provisions for keeping orders on vessels, which include the promoting seafarers' qualities, and latter are related to seafarers' employment agreement. In short, Seafarers Act is mandatory, public, and private law in legal nature. That being said, formal source of maritime labor laws are as follows: Seafarers Act, Enforcement Decree, Enforcement Ordinance, Rules on the safety and hygiene of seafarers, Regulation on Seafarers Labor Inspector, Regulation on Seafarers Labor Committee, Minimum wage for seafarers, Instruction on the procedure of seafarers' affairs, Instruction on the calculation of normal and average wages. However, there are other laws which are also used for material source of maritime labor laws, namely Labor Standards Act, Civil Code, Commercial Code, Ship Officers Act, Employment Insurance Act, Ship Safety Act, Maritime Safety Act, International Private Law, Trade Union and Labor Relation Adjustment Act, Occupational Safety and Health Act, Equal Employment Opportunity and Work-Family Balance Assistance Act, etc. These laws or codes are partially or entirely applicable to seafarers as well. Therefore, when you are dealing with the seafarers issues, you need to check what these laws or codes require to meet. Many scholars recommend that the Act should be separated into 2 or 3 laws, which I also agree. Looking at the structure of Seafarers Act, the Act itself consists of 18 chapters and 193 articles. The Enforcement Decree consists of 8 chapters and 80 regulations. An Enforcement Ordinance consists of 15 chapters and 106 regulations, which means the Act itself is quite extensive. Chapter 1 in the Act sets out general provisions. Firstly, you have to understand and keep in mind that the purpose of Seafarers Act is to secure and improve seafarers' basic life, to keep the orders on the vessel and to promote seafarers' qualities and competencies. Among 3 purposes, the first purpose is related to labor protection, and second and third are related to the human safety on board the ship. Therefore, when you read provisions under the Seafarers Act, you need to try to understand which purpose or purposes would be related to those provisions. Now talking on the scope of application. The Act is applicable to ship owners and seafarers on board, Korean merchant ships and fishing vessels, foreign flag ships chartered on condition of flagging in, and foreign flag ships plying Korean domestic ports. These foreign flag ships chartered on condition of flagging it means virtually hire purchase bareboat chartered ships. Regarding the scope of application relating to ships, the following ships are exempted: the ship of less than 5 gross tons other than seagoing ship, ships navigating in inland lakes and rivers, exclusively or within harbor other than tugboats, fishing vessels of less than 20 gross tons engaged within near continental waters, barges, including those registered to be used for shipping business, and ships of Navy or Korean Coast Guard. Thus, fishing vessels of less than 20 GT are exempted from the Seafarers Act, but the Labor Standard Act is applicable to these fishing vessels. In order to efficiently implement the ILO's Work in Fishing Convention 2007, it would be recommendable to extend the scope of application regarding fishing vessels. The Seafarers Act is partially applicable to trainees on board. This is related to the safety of trainees, the protection of trainees, compensation for the cases of occupational accident, etc., etc., etc. The ship owner related provisions shall be applicable to any person who employs seafarers to pay him or her for the service on board, irrespective of employer's title, namely ship owner, ship leasee, manager of ship, charterer. Talking on some of the important definitions under the Act. Firstly, on the definition of seafarers, which means a person who is employed to provide labor in a ship to which this Act applies, provided that those prescribed by presidential decree shall be excluded. The presidential decree provides such exclusion as follows. The ship inspectors, technicians and workers temporarily joining a ship for the purpose of repairing the ship, harbor pilots, workers employed for the purpose of running a harbor transport business. And next is persons joining a ship for taking onboard training, which means that cadets are excluded in Korean case. Persons joining a ship for taking onboard training for the purpose of becoming a seafarer. Celebrity joining a ship temporarily for public performance. Any person announced by the Minister of Oceans and Fisheries as he or she is regarded as a comparable person to one of the paragraphs 1 through 6 above, after consultation with the representative of ship owners and seafarers organizations. Secondly, ship owner means an owner of a ship or another organization or person, such as manager, agent, bareboat charterer, etc., who has assumed the responsibility for the operation from the owner and who, on assuming such responsibility, has agreed to take over the rights, duties, and responsibility imposed on the ship owner in accordance with this Act, which is virtually the same definition as prescribed under the MLC. Thirdly, seafarers' employment contract or agreement means a contract made for the purpose that the seafarers goes on board and provides a ship owner with his labor, and ship owner pays wages in compensation for the labor. Views on the relation of Seafarers Act and Labor Standard Act is splitted in Korea among scholars. However, Korean court's position is that both laws are equally legally equal footing. Therefore, it can be said that Seafarers Act is a special law of civil laws, which means that when a legal argument cannot be resolved with a Seafarers Act, then the relevant provisions under the civil law can be applied to resolve the case. The following 5 major principles contained in the Labor Standard Act are also applicable to seafarers. Firstly, equal decision power on labor conditions and observing them. Second, equal treatment. Third, prohibition of violence to workers. Exclusion of intermediary exploitation. Guarantee of suffrage, which means right to vote. Chapter 2 describes the master's duty and authority, which is a public law in nature. Regarding, firstly, the authority of a commandant, the master, also is known as captain, is authorized to direct and command the crew of a vessel. May command any person on board to perform his or her duties. Secondly, the obligation of inspection before sailing. The master is obliged to inspect the vessel's seaworthiness to complete the voyage prior to the vessel's departure from a port. This is virtually the same as the ship needed to be made seaworthy at the time of departure under the commercial code. Upon such inspection, he or she shall submit the result of inspection to the ship owner, and the ship owner shall take necessary measures to ensure the safety of the ship and her safe operation. Regarding the accomplishment of voyages, the master is obliged to get underway of the vessel upon the completion of the preparing the vessel's sailing without any delay, and to proceed to her destination along the routes scheduled, except the case of unavoidable circumstances, which means that master shall navigate along planned sea route. In respect of the master's direct command, the master shall command the vessel directly when the vessel is entering or leaving a port, when the vessel is passing a narrow channels, when a ship is passing through any waters within which marine casualties, such as collision, sinking, etc., have occurred frequently, or other cases which could cause dangers to ship, as prescribed by the Enforcement Ordinance. The Enforcement Ordinance provides other cases as follows. Firstly, where there is a risk of a ship running aground or colliding with another ship due to remarkably restricted visibility caused by fog, narrow or snow or rainstorm, etc. Secondly, where maintaining a ship's course is difficult due to sea current, tidal current, or strong wind, etc. Thirdly, where a ship encounters a group of fishing vessels while at sea, or there is a remarkable increase in traffic on the route on which a ship is navigating. And lastly, where a ship is not likely to be operated under normal conditions, including malfunction of the equipment for the safe operation of a ship, etc. With respect to the duty to stay on board a ship, the master shall not leave the vessel from the time of beginning of loading cargo or of boarding of passengers until the completion of unloading cargo or of landing of passengers. However, that in cases where there is a special reason that he or she should leave his or her ship, such as abnormal weather conditions, etc., this shall not apply where he or she has appointed a person who is to perform his or her duty on his or her behalf from among officers. In relation to measures to be taken in emergency, where a ship is in critical danger, a master shall take all measures necessary to rescue human lives, the ship and cargo. A master shall not leave his ship before he takes an action to rescue human lives. The above shall be mutandis mutantis applicable to seafarers. In relation to measures to be taken in case of collision of ships, when ships collide with each other, the master of each ship shall take all measures necessary to rescue human lives and ship and inform the counterparty of the name of his or her ship, the ship owner, port registry, port of departure, and port of arrival. However, this shall not apply where a ship under his or her command is in a critical danger. In respect of the duty of rescue of a vessel in distress, when a master comes to know the distress of another ship or airplane, he or she shall take all necessary measures to save a life when he or she acknowledges a distress of a ship or an airplane, unless, firstly, the vessel in his or her command is in immediate danger. Secondly, notification was received from another vessel on the scene, there is no need to rescue. Thirdly, he or she considers it impossible or unnecessary to rescue on account of inevitable reasons, although having approached distress location. Fourthly, he or she considers it impossible to approach to the distressed location or inappropriate to rescue on account of inevitable reasons. In respect of the duty of informing abnormal weather conditions and etc., when the master of a vessel encounters with abnormal weather conditions or sea states such as a storm or any floating or sunken object which may be dangerous to ships sailing, such as for floating ice, he or she shall inform the master of nearby vessel and the chief of competent Coast Guard office such findings. Details of notification can be seen the attached table 1 of the ordinance of minister. However, this regulation shall not apply to the case that the administrator of meteorological administration or chief of competent Coast Guard office has already forecasted such dangers. In respect of the duty of a masterist and drill, a master is obliged to post master list describing the tasks that the seafarers ought to perform in the case of emergencies in a conspicuous place on the ship, conduct drills with those who are aboard, including fire drills, survival craft and rescue boat drills, etc., etc., etc. In such cases, seafarers shall participate in drills, performing tasks allocated on the bill, and execute the above drill against emergencies without any interference with the crew's rest. This obligation is applicable to ships of no less than 500 gross tons. However, that this shall not apply to a ship trading in near coastal waters and the passenger ships. For all passengers aboard to evacuate in an emergency, a master of a passenger ship shall specify the information about emergency signals and locations of mast stations and life-saving equipment, post the evacuation procedures, etc., in easily visible places on the ship, inform passengers on the ship of how to use life-saving equipment to escape in an emergency and to provide other notifications needed under similar cases. How often the drills needed to be conducted are as follows. For ocean-going passenger ships, the drill needed to be conducted once every week. For domestic passenger ship, drill need to be carried out once every 10 days. For cargo ship, once every month, and within 24 hours upon change of 1/4 or more of crew member. A master shall commensurate the seafarer's break time when he or she performs an emergency drill. Master shall use lifeboats in rotation when he or she conduct lifeboat drills, preferably bi-monthly by having them afloat on sea one by one. Method for making emergency signal shall be a combination of 7 short consecutive blasts followed by 1 long sound of whistle or siren. The contents of emergency drill shall be recorded in logbook and make a video or take a picture of such and keep them whenever there is an emergency drill on a ship. Master or designated officer shall inspect and maintain the life-saving appliances, means of escape, and other matters on ship safety through patrolling the ship once a day and record the result in the logbook. In case that a ship is flying same destination twice or more a day, the patrol shall be made every voyage and the result must be also recorded. In respect of securing the safety of navigation, master shall ensure the safe navigation, including execution of a navigational watch, fire prevention, and the following. And firstly, observance of collision regulation. Secondly, observance of the SOLAS Convention. Thirdly, the regular inspection of all navigational aids and record keeping. Fourthly, regular inspection of crew accommodation and galley and record keeping. When a person on board a ship is dead, the master may bury the deceased body at sea on condition that ship shall be at high seas. 24 hours has elapsed upon death, except death from an infectious disease. Preservation of the deceased body on board is not possible due to hygiene, or is planned to enter the port where it is prohibited to carry the deceased body or ashes. The doctor must have made out a death certificate in case a doctor is on board. In case of death from an infectious disease, a doctor or a person in charge of medical care has completed appropriate disinfection. Master shall execute burial with appropriate formalities and take a proper action that the deceased body should not upload. However, this act was amended recently to prohibit burial at sea in principle. Burial at sea can only be allowed in unavoidable situation. Therefore, revised Seafarers Act prohibit burial at sea in principle. But when, as I explained in previous slide, only that condition, then you can bury at sea. So therefore, in principle, you must deliver this body or ashes of body to the family or next kin of your family. That is the recent revision of Seafarers Act. Regarding the duty of keeping the article left behind, when a person on board the ship is dead or lost, master shall retain the hair, the articles, etc., left by the deceased. Make out the list of articles left with 2 witnesses. The list shall contain the following items. First, the name and address of the deceased or lost. Second, the date and time and location of death or lost. Third, the name and quantity of articles left. Fourth, the date of inventory and making out the list. Last, in case of other treatment made, the reason and the contents of treatment. Master shall deliver or issue the articles left and the list thereof to the family of the deceased or the lost. Regarding the duty of keeping document on board, first, master shall keep the following document on ships. This is somewhat related to keeping seaworthiness in relation to duty of the shipping companies. First, a certificate of registry of the ship. Second, a list of seafarers. Third, logbook. 4, documents concerning cargoes. And 5, other documents prescribed by the ordinance, enforcement ordinance of the Ministry of Oceans and Fisheries. Second, a master shall record and keep a list of seafarers and logbook, etc., according to the form prescribed by the enforcement ordinance of the Ministry of Oceans and Fisheries. The enforcement ordinance requires that the following documents also need to be carried on board a ship. First, ship inspection certificate. Second, nautical chart of the navigation area. Third, an engine logbook. Fourth, a list of fitting. Fifth, safe manning document. Sixth, a copy of insurance policies of accident compensation. Wage claim and repatriation that designate a seafarer as a beneficiary, or a copy of a document that demonstrates a fund is established to guarantee the payment of outstanding wages of seafarers. And finally, books that contain contents of the Maritime Labor Convention 2006, excluding a non-seagoing ships and a fishing vessel. Therefore, a book of the Maritime Labor Convention need not to be carried on board non-seagoing vessel and fishing vessels. Regarding the duty of submitting report on ship operation, in any of the following circumstances, the master shall report such a fact to the competent maritime affairs and port authorities without delay. First, when a ship collides, sinks, is destroyed or lost, suffers a fire, run aground, suffers damage to engine, or other marine accident occurs. Second, where a master comes to know distress of another ship on a voyage, excluding cases where he or she comes to know such distress through wireless communications. Third, where a ship is engaged in the rescue of human lives or a ship. Fourth, where a person aboard a ship dies or is missing. Fifth, where a master changes the planned sea route. Sixth, where a ship is detained or seized. Last, where other serious accidents happens on a ship. Now, Chapter 3 sets out the provisions relating to maintenance of order on board. Article 22 of the Act stipulates that paragraph 1, where a crew falls under any of the following cases, a master may take disciplinary action against a crew. First, where a crew fails to obey an official order of his or her superior. Second, where a crew leaves a ship without obtaining permission from the master. Third, where a crew carries a lethal weapon or narcotics under Article 2, Paragraph 1 of the Act on special cases concerning the prevention of illegal trafficking on narcotics, etc., onto a ship without obtaining permission from the master. Fourth, where a crew fights, assault, drinks, causes a disturbances of damages, structures intentionally on a ship. Fifth, where a crew neglects his or her duties or interferes with the performance of duties of other crew. Sixth, where a crew fails to go on board a ship by the time appointed by the master without a justifiable reason. Last, where a crew conduct any other act prohibited by a collective agreement, the rules of employment or seafarers' employment agreement as an act disturbing orders on a ship. The kinds of disciplinary action shall be admonition, prohibition from taking shore leave and being forced to leave the ship, and the period of prohibition from taking shore leave shall be less than 10 days while a ship is at anchor. The disciplinary action of being forced to leave the ship shall be taken only when it is obvious that crew's behavior seriously distract from maintaining the order on board, or that the crew's intentional behavior causes serious hindrance to the vessel's operation. When the crew is discharged from the ship by the punishment, the master shall inform a ship owner without delay that he or she has taken such disciplinary action. When the master wishes to take disciplinary action, the procedures in advance shall be subject to the decision of disciplinary committee made up of 5 members or more, where the number of crew is less than 10, referring to 3 crew members. The disciplinary committee shall consist of chief engineer, chief officer, second engineer, chief radio officer, bosun or number 1 oiler. A meeting of disciplinary committee shall be convened at the request of a master. The disciplinary committee shall give opportunity of making statement to the person to be punished. Where deemed necessary, the committee may have another crew attend a meeting and make his or her assertion. Where the disciplinary committee determines disciplinary action against the crew, the committee shall prepare disciplinary review documents and a record of discussion signed by the members thereof.